Good afternoon. My name is Marina Lamm. I'm a patent attorney from the Office of Policy and International Affairs here at the USPTO. I'll be a moderator of this next panel. This morning, a number of panelists and participants mentioned and talked about international licensing. So this panel will discuss the challenges and opportunities in international licensing in greater detail. Joining us today are Mark Cohen, Senior Counsel at the Office of Policy and International Affairs at the PTO, Gaétan de Rassenfosse, Chair of Innovation and IP Policy from the Swiss Institute of Technology, and will be joining us shortly David Cohen, Chief Legal and Intellectual Property Officer from Vringo in New York City. He's on his way, apologies for that, but he'll be here in a minute. We'll start with Mark. Mark, you have over 30 years of experience both in the private sector, in academia, and in the government, working in China and with China on various IP issues, including technology transfer and licensing. Based on your extensive experience, could you give us an overview of the licensing climate in China?
Happy to do that. This is one of my favorite topics. Actually, this program, to a degree, came out of the China team at the PTO. Hello, hello? Okay, there you go. This program, to a degree, came out of the China team at the PTO out of a sense of the frustration or difficulties that we thought U.S. companies were experiencing with regard to their ability to monetize their assets, their IP assets in China. So the topic of licensing and commercialization of technology in China, for me, goes back some time, and I think it's become more acute as an issue as time goes by. I gave a little hint of the issue this morning in one of the questions I raised about the data and the reasons that China seems to be have an odd profile in terms of the amount of technology exports coming out of the U.S., the amount of licensing revenues we get out of China. And I'm going to go through that. Hopefully this will shed some light on other countries as well, although I'm not going to presume too much that the whole world is like China. I hope it isn't. I hope it has other issues than the ones we see in China. In general, as I said at actually the House Judiciary Committee yesterday, the good news is China believes in IP. The bad news is China believes in IP. China really does believe in IP, but it's also part of state industrial policy. It's not a free market-oriented approach. It doesn't respond or manifest itself in the ways that other people might assume a country should at that stage of development and economic activity. And I'll go through what this looks like in terms of licensing revenue, why it's so low, China's own goals, and the challenges to technology transfer, particularly in terms of the indemnity issue that I raised just recently. So this is what China looks like in terms of licensing revenues. And we make a little bit of an apples to oranges comparison here for want of a better comparison about U.S. high-tech licensing receipts, which you see on the right. You can see that the amount of U.S. high-tech IP licensing receipts that China contributes is about 5% of the total. It's about $6 billion out of $130 billion. And it's gone up from about 2.4% to 5% over a period from 2004 to 2014. Yet at the same time, if you look at high-tech exports, you'll see that China about doubled in terms of the contribution it makes to high-tech exports globally. So China is about 20%, 21% of high-tech exports. So we're comparing licensing receipts to high-tech exports. Now, perhaps the U.S. portfolio in high-tech is not as robust as other countries. Perhaps it's more robust. But just making that linear comparison would suggest that at 5% of receipts and 20% of high-tech exports, China may be under-licensed by a magnitude of 400%. It should be about 4 times the current amount of licensing revenue, or about $20 billion, which to me is real money. But again, growth lines roughly parallel. It seems. There's David Cohen. Hey, David. Hi. By the way, no relation. At least not that we're aware of.
I'm shocked at the promptness of the. It's actually early.
Yeah, we're always prompt in all things, you know. But, well, we ended a little early, so we decided to
I'm impressed.
Actually, one time David and I were in a program with Jerry Cohen. It was the 3 Cohens, all no relationship. But that can only happen in New York, I guess. So licensing revenues, China, U.S., so you see that actually the good news is that the amount of receipts from China beginning around 2009 on the heels of the global financial crisis to today have steadily increased. We're now at about $6.5–7 billion. And actually China is starting to export more technology to the U.S. About $0.3 billion, still a fraction of what the U.S. collects, but it is increasing, and there are target goals for China to obtain more in technology transfer. The interesting thing is the profile. Why is it that compared to, for example, East Asia and Brazil, to take some developing world regions, most of the licensing revenue coming to the United States from China is from affiliated enterprises. The minority is unaffiliated enterprises, whereas for the rest of the world, it's largely unaffiliated enterprises. So this is a typical situation. I think Mark Ehrlich talked a little bit about it. IBM, New York licenses to Huawei, Dallas, which then sublicenses it back to China, or GE Schenectady licenses to GE Shanghai, which then sublicenses into China. It seems to be most of the licensing transactions are largely affiliated. If you look at the cell phone area, you would assume, for example, that almost all those licenses should be unaffiliated. Qualcomm, I don't know if Qualcomm makes any more cell phones in its own name, but we see a huge growth in unaffiliated production. So what are the reasons revenue is so low? Well, one of the things we shouldn't forget, of course, is the IP environment is weak. Average damages, this is 2014, 2015, which is actually a little bit more glowing than if you went back about 5 years. Average first instance damages in a patent case, $25,000 US. Probably not enough to cover the initial retainer of even a smaller firm for a patent dispute in the United States. High win rates. You're likely to win, but you're not likely to get much money. Maybe you'll get an injunction, and maybe that will be enforceable. Creates an interesting comparison between antitrust damages, remedies, and patent damages. Again, kind of an apples to oranges comparison, but if you looked at the Qualcomm antitrust penalty, $975 million, and if you did the average patent damages awards for the past 5 years or so, about $18,000, that's a 50,000 to 1 ratio. And believe me, I've done the math several times because you have so many zeros I've had to check, and I had someone else check. 50,000 to 1 ratio between average patent damages in China and the Qualcomm antitrust fine if you went back for that average calculation about 5 years. Even a more robust recent level, some calculations, maybe be at about 15,000 to 1. Huge discrepancy. Shows that there are real risks in protecting your IP in China, and there's real risks of being caught up in the antitrust environment, which also probably licenses the incentives to litigate in China or to enforce your patent rights in China. And David Cohen may speak to that a little later. But not that I'm giving David...
Or enforce your patent rights against the Chinese company.
Right, exactly. So not that I'm giving legal advice to David, but the data clearly makes out a strategy about how to enforce. So why is revenue so low? According to a U.S.-China Business Council survey, that 59% of respondents expressed concern about transferring technology to China. Principal concern, protection of IP. If you transfer it, you lose it. Another one, enforcing a license agreement, concerned about the courts, notwithstanding the high likelihood of success, and that the government may be dictating or influencing legal licensing negotiations. China, in another survey USCBC did, a non-public survey that we actually worked with them on, that we're trying to replicate in other markets, actually, and by other associations. China was rated as the most challenging legal and regulatory market ahead of the U.S., Europe, developed markets in Asia, and other emerging markets. And to speak to Mark Ehrlich's point earlier today about choice of law, China was, another survey shows that China was a largely disfavored market, a disfavored choice of law jurisdiction for technology transfer contracts. New York and other markets were more favored, notwithstanding that to enforce a contract in China, you're much better off choosing Chinese law. Choosing foreign law, you could run into real speed bumps. An AmCham survey, 49% of respondents believe that lack of IPR protection constrains their investment in innovation. And they also said that the top 3 perceived competitive advantages of U.S. companies were brands, technology, development, and innovation. Very IP-intensive stuff that we view as our competitive advantage, yet real difficulties in licensing it, fear of licensing it, and fear of enforcing agreements. I mentioned the Qualcomm judgment 50,000 times. Won't go through that again. One of the surprising elements of this whole equation, or maybe not so surprising when you look at damages, is that according to official Chinese data, and we could question how complete that data is, but that data has been consistently applied, the amount of foreign involvement in the Chinese IP system, the amount of foreign-related IP litigation, was 1.3% of the total last year. 1.3, again, just to repeat that number. And that actually dropped from 1.8 the prior year. It dropped in both relative terms and absolute terms. So if you're looking for an indication of lack of confidence in the legal system, whether it's deserved or not, I think you have the very concrete number there. And in an environment that is increasingly litigious, 100,000 or so cases per year for IP. Foreigners constituted 1,327, and it was a drop of, about 30% from the prior year. Whenever a number goes down in China, by the way, if you want one simple Cohen's rule on looking at Chinese numbers, if a number drops from one year to the next, there's something going on. Because the economy grew by 10%, and all the government officials want to show even greater growth than that. So when you have a drop like this, you got to wonder how come it dropped. Foreign companies feel targeted, maybe one reason. Antitrust cases have indicated that. 30% of companies said they felt they might be targeted by future antitrust investigations. David, you may have some experience on that issue.
Yeah.
But let's hold the suspense for a little later. But just 21% had undergone a MOFCOM merger review. 18% reported experience with pricing or competition-related investigations. Why do they have this fear? Well, part of the reason is it's a planned economy. By the way, a lot of people go to China, see beautiful high rises, lots of educated, interesting people. There's still an economic plan, and the antitrust law and many of the IP laws say that the goal is to implement the goals of a socialist market economy. If you can tell me what that oxymoron means, socialist and market, please raise your hand and educate us all. In terms of technology, the goal is to reduce dependence on imported technology to 30% or below. Think about that, what I just said about statistics. Economy is going up. Foreign technology, they want to go down. Again, anytime you see that number drop, something is going on, and here we clearly have it as an industrial goal, reduce dependence on imported foreign technology, even though it seems to be an underlicensed economy. And China also talks about its own goal of increasing technology exports from 1.3 billion USD to 8 billion. There are tax incentives also associated with these programs. And this is the one thing I just wanted to highlight as one possible cause, or at least a contributor, to this kind of skewed environment where it seems to be an under-licensed economy and a lot of tech transfer between related parties. And that is a regulation called the Technology Import-Export Regulations require a foreign licensor, only a foreign licensor, to indemnify a Chinese licensee against third-party infringement. Okay, so if it's a domestic transaction, you can fully negotiate it, no problem. If it's a Chinese export of technology, There's no restriction under Chinese law. There may be under the recipient country's law, but not under Chinese law. But when it's a technology export to China, an American selling technology to China, there's an indemnity requirement. So how would that manifest itself? One thing which I'm proposing is that you see a lot more related party transactions. You probably see much more limited access to startup companies. China has big companies now, by the way. Some of them are pretty darn sophisticated. So if a startup company in Silicon Valley of 150 employees has some really interesting technology for smartphones and Huawei is interested, well, that 150-person company is going to have to indemnify 60,000 employee Huawei, or however many employees they have, which has a lot more access to capital and information, and they're probably going to be very reluctant to do that. In fact, even if it's IBM that wants to license to China, and they're willing in certain markets to take on an indemnity obligation, when you have a patent office, which Dave Kapos just told me has more patent applications than the other 8 next biggest patent offices combined, and the most litigious society in the world, whose administrative patent litigation is greater than the combined number of U.S. civil patent cases, Chinese civil patent cases, and Section 337 cases combined. And when 2/3 of the patents that are granted by China are not examined for substance, what person in their right mind would offer an indemnity against third-party infringement? You can't even do your FTO opinion unless it's going to be at great expense. So that is also another significant impediment because of the high risk. And if you're just a startup and you're not licensing for that much money, you're not really selling technology anymore. You're selling insurance because you're selling an indemnity. How negotiable is it, et cetera, hard to say, but that seems to me that that's one of the impacts. And I think this creates an unnecessary frustration by the Chinese who may say they're not accessing leading-edge U.S. technology. That's right, because you want insurance with it, and nobody wants to sell insurance when they sell technology. So this is the provision of the technology import-export regs. The transfer bears liability. Foreign governing law not likely to work. Other options: creative lawyering, use arbitration, et cetera. All these things could perhaps mitigate risks. As I mentioned, it's a big issue for startups. Wang Xiaoye, a leading antitrust scholar at the University of International Business and Economics, I think, in my mind, understated the obvious, but is one of the few people to state this at all, that under China's current IP regime, licensors' interests appear to be insufficiently taken into account. And I think that's the case, and it affects U.S. exports of technology. And that's the reason we have that graph yet again. Thank you.
Thank you very much for this overview. So, Gaétan, Mark just mentioned low foreign participation rate. And I believe you recently done some research on industrial policy in China and how it affects foreign patenting and patent licensing. Could you briefly talk about that?
Microphone, just closer.
All right. Okay, let me repeat the question. I apologize for that. So Mark mentioned low foreign participation rate, and our next participant recently done some research on the topic of industrial policy in China and how it affects foreign patenting and foreign patent licensing. So I'd like to ask Gaétan to briefly talk about that research. Thank you.
Thank you very much, Marina. So I'm Gaétan Rassenfosse, assistant professor in the economics of innovation in Switzerland, in Lausanne. And indeed, I've done some work on how industrial policy in China in particular affects the patent system and hence reverberates on technology licensing, even though I will just focus for the next 10 minutes, 7 minutes on the first part, the impact on industrial policy on the patent system. But first, let me set the stage, right? And in fact, Alan Marco did it superbly this morning, explaining why patents matter in technology licensing. So I tend to, to see patents and the patent system as a lubricant in the market for technology. Really, patents is a precondition. The patent system is a precondition for technology licensing. So as Alan mentioned, we have that arrow information paradox, right? So if you want to disclose a technology, you better, in order to be able to sell it, right, you better make sure that you have protection or something protecting you in case the deal doesn't get done. So it protects sellers against second-party expropriation, but of course also prospective buyers against third-party expropriation, right? Just buyers are, with the patents, buyers are just protected and make sure that their profits are protected. Another reason why the patent system matters in technology licensing is through the disclosure requirements. So the fact that patent applications are published 18 months after submission actually act or signals to prospective buyers that the technology exists, right? And it's potentially available for licensing. So it has been shown by colleagues of mine, Deepak in particular, Deepak Egg in NYU, that disclosure requirement signals potential buyers that the technology exists, and hence speed up licensing rates in the economy. So that's why we actually usually say that the patent system is a precondition for technology licensing. However, let me qualify that sentence. A well-functioning patent system is actually a precondition for technology licensing. And we can think of a variety of ways in which industrial policy, and here I will focus on China, but in a variety of ways in which the industrial policy may actually distort or induce frictions in the market for technology. So one issue, it's the lack of enforcement or the difficulty of foreign firms to enforce their patents in China. And if you are not able to enforce your technology, what's the point of licensing it in the first place, right? So Mark discussed it, but I guess David will come back, might come back to it in his talk. Another issue in which industrial policy may affect the licensing rates, it's simply through a lack of patent quality, right? So the China, well, as David mentioned, as Mark mentioned, I get confused, China takes IP seriously. In fact, China committed to increases in the number of patents dramatically and even give subsidies to firms, right? So that increase in patent application that has resulted from these subsidies actually has come up with a very low, or is associated with a very low quality of patents. So by many standards, the quality of Chinese patents is fairly low. So this lack of quality introduces basically noise in the patent system, which makes it difficult for licensee to identify promising technologies. But I want to focus on the third issue, which is much less discussed, but to me equally important. Industrial policy actually prevent some foreign firms to get patents. So that's obviously a very important question in terms of technology licensing, because if you don't get a patent in the first place, given that a patent is so important, well, you have no opportunity for licensing your technology, right? And so that discrimination or bias against foreigners in the Chinese patent system actually is a very central element to international IP law, right? So we have what we call the National Treatment Principle, NTP, which has been, first mentioned in the Paris Convention for the Protection of IP in the 19th century, and has been reaffirmed in the TRIPS, the trade-related IP agreements of the WTO, right? So according to Article 3 of TRIPS, each member state should actually accord to the nationals of other members treatment no less favorable than that it accords to its own nationals. So that's a very central element in IP law. And there are many good economic reasons for having this type of agreement, right? However, recently, foreign companies, and especially here, US companies, European companies, to my understanding, has been much, much more shy on that issue, or on claiming that they face discrimination. So recently, foreign companies have expressed mixed concerns that there might be an anti-foreign bias in the issuance of patent application at the Chinese Patent Office, in particular in areas that the Chinese government consider of strategic importance. So that really brings us to the heart of the industrial policy, right? So let me come back to, both the foreign bias, anti-foreign bias, and the strategic importance. These are two important keywords. But when you think of it, if you want to understand, to try to prove this claim, and which is basically what I will be doing, or trying to do, if you want to prove these claims, you actually have to understand the many factors that affect the probability that you will get a patent granted in the first place, right? So starting from the top left, you have given an invention. Well, a few factors can actually affect the probability that you will get a grant, right? The quality of the attorney firm that you use actually might affect it. Maybe some firm effects. So maybe some firms are just better in managing the patent process, and interacting with the office, for instance. More importantly, of course, invention quality, right? So some inventions simply do not deserve patent protection. Technology effects, right? So we know that the grant rate differs by technology fields, and you can think of other millions other factors, right? However, there is one factor that should not affect the probability of grant, which is simply, the country of residence of the applicant, right? So according to the national treatment principle, it shouldn't make a difference whether the firm is, based in China or whether the firm is based in the US or in any other country. Second aspect, that we try to establish, apart from country of residence of the applicant, is that strategic areas, right? So now what we want to do is we will identify areas of strategic importance by looking at the national medium and long-term program for science and technology that Mark mentioned, which is basically a description of a few key technologies in which China wants to become a leader by 2020. So we go into the MLP, so in that plan, right, we identify the technologies and we map them to IPC codes with the help of examiners at WIPO, right? We take roughly 500,000 Chinese patent applications, so a massive amount of application, and we flag each application according to whether it is filed in one of these strategic area or not, right? Then we flag every application according to whether it is filed by a foreign firm or by a Chinese firm. Right, and then we seek to predict the grant probability, controlling for all the other factors that I mentioned. And if we do that, we actually, come to the conclusion that foreign firms have a 5 to 7% lower probability of grant if the patent application is filed in a strategic areas, right? If we talk to non-strategic technologies, there is basically the national treatment principle is being upheld, right? However, in these strategic technologies, well, then firms have 5 to 7% lower probability of grant. In practice, it means for every 100 patents they file, 5 to 7 will not be granted, will be illegitimately, unduly refused, right? So now we can dig deeper into some strategies, some of these technology fields, and we find that the effect is very strong in biotech, for instance, where this foreign discrimination is, depending on the model that we use, right, basically around 15%. So the probability of getting a grant is 15 percentage point lower than what it should be absent of this discrimination. In ICT, the probability of grant is a bit less than 10%, lower compared to Chinese firms, but the effect is particularly strong for SEP, standard essential patents, where the discrimination is close to 15% according to some specification, right? Third significant technology fields where there is a foreign bias is energy with a rate between 7 and 9%, right? So now, where does that lead us, and what role does that? What do we need from U.S. government and government in general, including the European Commission? Well, most political efforts in the area have been geared towards harmonizing IP law and ensuring better enforcement. And in fact, even though it's highly imperfect, there has been progress made, especially in China. However, as we have just seen, more subtle barriers remain. One of these barriers being insurance against foreigners. So that illustrates that the industrial policy creates frictions in the patent system, and hence by reverberation in the market for technology. And in my opinion, the U.S. government should ensure, as it does, right, that the NTP national treatment principle is being upheld, but on every dimension in which foreign discrimination could occur. One of these dimensions being issuance. Thank you.
Thank you very much, Gaétan. As far as you know, do other countries have similar biases, similar policies?
Well, so that's a very good point. Yes, right. In fact, it's in every country best interest, depending on the stage of development, to actually have these policies, right? So it's no big surprise that China does it, even though they actually signed these agreements. Well, Japan used to do it in the 80s, and even the US used to do it in the 19th century against, the British, or the British against the French. So it's very much, it's not a new thing, right? Other evidence by colleagues of mine actually show that this foreign bias exists at the EPO and the JPO, so they didn't test the USPTO. So part of the bias can simply be due to higher familiarity with the patent system. It could be the case that Chinese firms are just more knowledgeable about their own patent system and the patent process than foreign firms. However, in that study, we actually control for that. So really what we cannot explain, this 7 to 10%, is actually really a discrimination as far as we can tell.
If I could just ask a follow-up question too. So you've identified a lot of externalities, the law firm, familiarity with the patent system, et cetera. But you haven't identified any internal patent examination procedures that would suggest the bias. Now, anecdotally, we hear, for example, that if you go to the PRB in China, the Patent Reexamination Board, in general, as with courts, matters are not referred to the party committee except if they're politically significant. And I've heard also anecdotally that any pharma patent held by a foreign company is politically significant. And there may be similar procedures or similar political significance associated with a SEP or a strategic and emerging industry. And granted, I'm not saying those procedures are transparent or available, but it seemed to me it would help your argument if those differential treatment or reviews could be identified.
I think also, Mark, from practical experience here, that with SEPs, there are sorry, I'm between two mics. Sorry about that. With SEPs, there are definitely political interest, and I'm aware of that. I can't tell you how much more than that. And it would seem that another sort of thing that could be looked into is not just the procurement of patents, but the maintenance of patents in a reexamination, how that process works. Because one of the interesting things in China, at least I've learned, is you can re-examine the same patent over and over and over again on the same art. And the other thing that is interesting is that ex parte communication with the examination board is a matter of routine. And what you will often see happen, at least in my experience, is a panel will be interested in allowing the patent. The requester of the re-exam, I forgot what the formal term is in China, withdraws the request and then refiles the same examination request with a new panel. And so I wonder how much that also falls into the system. But as far as SCPs, I'm very aware of connections politically.
So a very quick reaction. So that's very much true. So we do not observe what's happening inside the office. We had a very long chat with IP people at some large European ICT company, right? Some of them actually mentioned that the reason for the effect that we observe could simply be due to the fact that some patent by foreign firms are being assigned to more experienced examiners, right? Or simply examiners who speak English, right? Which actually, just by the way the system has been designed, even though there is no political intention behind, would actually receive a tougher time. So we have no way of actually checking whether that is true. But even if that explanation is true, in fact, that suggests an unfair treatment of foreigners against Chinese firms. So even that would be a violation of the NTP, right? But you're right, we do not observe what's happening inside the system.
In fact, I would also suggest that a foreigner filing a patent in a foreign country, a U.S. company in China, is probably filing a higher quality patent because it's going to be a weeded out, smaller cohort. So all things being equal, there might even be a greater likelihood that it would be granted.
Thank you. David, can you talk about your practical experience doing licensing in foreign markets, including China, but not limited to China if possible? And what are the factors that you consider when you go into foreign markets?
Yeah. About 2 inches away. It needs to be about that close.
So I'll project and I'll repeat the question. I was asked by Marina to talk about my practical experiences licensing in China. So I was going to start off by saying that first I apologize for being late. I didn't think the patent office would be early, but always pleasantly surprised. And second of all, I was supposed to be part of a duo of Damon, I forget his last name, from Fulcrum. And, there's sort of two types of licensing, what often it's called stick licensing and tech transfer licensing. And Damon had a lot more experience than I do in tech transfer, whereas most of my experience has been in stick licensing. So, it's a little bit biased there, but and by stick licensing, it's a very blunt metaphor for take a license or we'll sue you. So that's sort of what stick licensing is, basically. But I would argue that at the end of the day, nearly all licensing, tech transfer licensing or other licensing, is ultimately down to the patents that undergird the license, because without them, unless there's high barriers of entry to reverse engineering, or there's some tremendous convenience to having the third-party licensor make the product, it's going to be ripped off, especially in cultures where ripping off is rather common, and that might be perfectly legal type of activity. And we're finding that on ourselves. Vringo is no longer Vringo Inc. We now changed it to Form Holdings Corp. Don't ask me about the name, but basically, it wasn't my choice, but basically, it's to reflect a broader holding of assets that we have, including a number of tech companies that we've acquired, including one, for example, that is premised on a licensing model where we have some specs that we license out for other people to make. And we saw immediately when we were at CES that certain people from certain countries were at the booth taking photographs, and we knew full well that they just had to buy one and they could reverse engineer it very quickly. So absent the patent to stop them from doing that, it'll be easily knocked off. And so I think at the end of the day, though, and what my experiences has shown me over the past few years is that patents really only have value if someone somewhere thinks you can mess them up bad with that patent. If they don't think that you can, or they know that you can't, like certain companies in China, then they really will not take it seriously. And that's been my experience. We've tried to license certain companies in China who don't have very much exposure outside of China, and they were more than willing to take the hit globally that we gave them, and were not interested in taking licensing until it became almost unbearable outside of China, and it was not worth their while, and there were other factors involved as well that Mark knows, for example, certain contractual breaches, NDA breaches, and things like that, which sort of also go into the play. But then there are other companies that we've dealt with in China more recently and more favorably who do have exposure elsewhere, and it was like night and day dealing with them. They have big exposure outside of the U.S., and we spoke to them. They took us seriously, and it led to swift resolution. And it's sort of, generally speaking, my experience. Maybe I'm biased because most of what I do is stick licensing at the end of the day. But my experience is if they don't think that you can mess them up somewhere, they're not even going to talk to you. Maybe there's a counterexample with some of the Japanese companies where they have most of their market share in Japan, and we all know that Japan is not a very good place to sue people. But I do think that there's sort of more of a recognition with a lot of the Japanese companies that you do have to pay for licensing because they do have exposure elsewhere at the end of the day. So that's basically my experience. I could talk about particularities, but that's at the high level.
Thank you very much. Why don't we take questions from the audience, if there are any?
This is Alan Szymanski from the chamber. Along with a question for any of the panelists, along with these strategic industries that they identified, a question I have in the issuance area of patents and unfavorable decision for foreigners, how much do you think the impact of whether there's an actual significant domestic player in one of those industries? I kind of wonder about that, even though it's a policy to support those industries. If there's not a current domestic strong player in that sector, would they still grant the patent to a foreigner? Just wondering.
That's an interesting question, Ellen. I can't answer it with respect to the Patent Office, but I do think that we may have examples in civil litigation where you have the perfect storm in terms of the improbability of foreign companies succeeding in a civil litigation. I do think that we do have examples in the civil system where there may be a perfect storm where there's a highly improbable likelihood of success that a foreign company would succeed in a civil litigation. And to me, the Schneider case may have been of that ilk. The Knowles case in Yentai may have been of that ilk. There may be others. What would be those factors? A locally connected company is able to sue or have the venue transferred to its home court. That's obvious. Foreign companies also file where they're most well connected. So a locally connected company does that. The locally connected company may have gotten its patents subsidized during the process of filing at SIPO, which means the local patent office gave them some money to support them. Local government may have recognized them as an innovative company and whatever rewards attached to that. They may have gotten tax preferences to build out based on their patent portfolio. And if they're a state-owned enterprise, the same local People's Congress that approved the hiring of the judges to the court also approved the appointment of the CEO. In that case, the foreign company goes to litigate against the company, and the implications for the government structure are too enormous, whatever the merits of the foreign litigant, because you'd be saying that the recognition that they're innovative, the recognition that we didn't spend money well to support their patent filings, the recognition that we had a CEO who was committed to innovation, et cetera, would all fall by the wayside. In that case, and there may be a national innovation strategy or local innovation strategy tied behind it, it seems to me it's very hard for even a well-meaning judge to strike an independent course and say, no, you really are infringing. I think it's a little harder to identify with the PRB, which has more of a national platform, if you will, that it's accountable to, and also to the Beijing courts. But one could see those kinds of efforts if you have a national policy like the medium and long range plan or the strategic and emerging industries, heavily subsidized, heavily recognized, maybe subsidies for SEPs, including participation in standard setting bodies, and China does that. And then you have, Huawei and others at one time making a big deal about how many patents they had that was standards essential, and then they sue. And probably the PRB is under tremendous political pressure in that case, whether directly or implicitly, to rule in favor of the Chinese company, simply because of all those government mechanics and weight that are leaning against them. That's my thought.
Well, not just to pick on China, though. I think that the concern is in a lot of countries where there is a strong national champion. I mean, I know, just look at the challenges Ericsson's having in India right now with the competition authorities. There's a strong national champion that will sort of make it more challenging for a foreign IP holder to get paid, let alone to be victorious in court. And in some countries, where there is no national champion, if there's a concern, this is at least in my experience, that your actions as a potential licensor would raise the costs for the domestic population of some industry that's important, say cell phones, that they may make you go through a lot of hoops before they allow anything to happen to the defendants or the licensees, and I've seen that in a number of countries like Brazil and whatnot.
So just quickly to follow up, at least on the China case, in fact, most of the discrimination, so the large majority of these strategic patents are in ICT and are, being owned by companies such as Qualcomm and Cisco. So clearly discrimination really occurs there. But in China, national champions and strategic technologies really go hand in hand. So you will have some national champions, right, in all these strategic areas.
You know, something that's always amazed me about China too, and I shouldn't harp only on China, but it's the only country other than the U.S. I seem to know pretty well. You know, whenever there's a significant case, whether it's in the PRB or in the courts, you frequently find conferences, sometimes with the support of the Chinese Patent Office, devoted to the topic presented in the case. So there's sometimes this kind of a consensus evolving, and frequently it does involve a foreign company. And as I think David or others have mentioned, ex parte communications are common. So there's ways that this information comes into the system that are not transparent, which inevitably also affect the case.
It's also the explicit activity on behalf of the courts, whether the chief judge of the Guangdong People's High Court, I will mispronounce his name, basically stated on the court website that Chinese enterprises should bravely employ anti-monopoly lawsuits to break down technology forces and win space for development. That's a translation of the exact quote in Chinese. I can't guarantee the translation, although someone at Veritexted it. So, you know, there is a policy on multiple levels to make space for domestic development.
Okay, thank you. We have another question.
Hi, Sherry Knowles. Of course, I'm involved in biotech and pharma. I was very interested in the statistic of the discrimination of about 15% against foreigners. And of course, we see that. But what we see is basically a difference in how they examine patent applications. Because what happens is in the United States, if you file a genus of pharmaceuticals or biotech, you can get a claim to one of those compounds, even if you don't have data in the patent application, as long as you can give the data later if asked, if the examiner says, I don't believe that, or I need some kind of evidence of unexpected results. In China, you can't do that. And in some other Asian countries, if you don't have the data in the patent application as originally filed, you can't get the claim to the compound. And the way this happens in the pharmaceutical file, patent application has a number of may have a broad genus and then a number of backups where you start to put your first compound through clinical trials or preclinical. That fails, you go to the next one, and you're still in tox or preclin or animal studies or something. You may go through a couple of compounds before you get to the one that you can actually do first time in man. It may be that first one you have the data on. When you get to the third one, you've got one that you've got the compound in the patent application, but you don't have the data. So what happens is you get to China, and China says, well, you know, we can't give you a patent on that because you didn't have the data. And that's a huge problem to the pharmaceutical industry and the biotech industry. And it's great to bring that up at the patent office. By the way, wonderful panel. You know, the issues in China are so important. But it's really important for the U.S. government to really acknowledge the fact that it's not just, we don't like you, we're not going to give you a patent. It's that they have set it up in a way that's much different than we do it in the United States. And we have that flexibility that they don't have. It can be that in China, they understand that system, so they're filing more narrow cases, maybe just to one compound or a couple of compounds. They get the data, then they file the next one to a couple of compounds. That's not how we do it here, and that's not how it's done in Europe. And I think that probably has something to do with that minus 15%, because we see a lot of rejections because of that.
I gave a lecture at Fordham at their annual IP conference this year, and I compared industrial policy and IP to these 10 famous pictures in Zen Buddhism called the ox herding pictures. Okay. Hello. Okay, so I gave a lecture at Fordham in the annual IP conference, and the topic was the 10 Zen ox herding pictures and the relationship to industrial policy and IP in China. And if those of you who know Cat Stevens, he had an album called Catch Bull at 4. That is from the 4th ox herding picture, Catching the Bull. The first picture, you don't even know the ox exists. You find the ox. You run after the ox, you catch it, and eventually there's some metaphorical disappearance of you and the ox. The point is you don't even know the problem exists, that there's industrial policy operating in IP in China. It's only later that you find out there isn't in a typical U.S. company, and then you're seeing it manifested perhaps in how data supplementation is permitted in pharma cases, or perhaps in how patent examination may have a bias in particular industries or against particular foreigners. Then you have to do, now that you've discovered this ox, and it's the ox that's the problem. It's not data supplementation. It's not the way a particular examiner is behaving. It's not even the way a particular court is behaving. That's just a manifestation of a loose industrial policy that's governing a lot of this behavior. Then the question is, how do you ride the ox as a foreigner? Can you ride it? You can't tame it, but you have to find some way of managing it in your own interest. And in some cases, it may be by bringing some things forward to the U.S. government if it can be addressed, or through statistical data that you mentioned. But you're absolutely right, Sherry. This is a real problem, and I suspect this. If it didn't manifest itself in data supplementation for enablement, well, then it would go to obviousness. And frankly, SIPO told us that. I think they told Dave Kapos at one time that specifically, that, gee, we made a mistake. We shouldn't be using enablement. We should be using obviousness. You're still going to get an invalid patent. So it's a whack-a-mole phenomenon where if you've hit it here, well, maybe they thought that's not the best strategy in addressing this issue. Move it to the next one or the next one. Maybe it would be enforcement at a later stage. But that, to me, is kind of the silent hand, the hidden ox, but which most people don't see of industrial policy.
So just to put some balance of the bashing, maybe a different country. I mean, another one that I recently became aware of some new developments in India on the concept of working, where it used to be sufficient to just say, your patents are licensed, and now you're required to give specificity. And as I understand it, Qualcomm has taken the unusual step, and I could be wrong about this, but I've seen some filings of specifically listing the chipsets to which the relevant patents are being worked. And that's a bit extreme if that's what you have to do, and not doing it could prejudice your ability to get royalties on those patents later.
Any other questions? Please.
Going back to...
Can you turn on the microphone?
It says it's on.
Oh, okay.
Okay. Going back to a specific issue that was raised, I believe, by Mark, that is how in China there's this requirement basically to indemnify. I'm just curious if any of you is willing to comment on how that may or may not be consistent with various multilateral obligations. Specifically, I'm thinking of WTO norms of reciprocity and fairness and things like that.
So we've had this discussion with the Chinese, and usually it comes back to a couple of things. One, the UNCITRAL Convention on Sale of Goods has an implied indemnity against infringement. At least that's what they've told me. The problem is this is not an implied this is a non-waivable indemnity. So the fact that the default is that indemnity and infringement, we wouldn't have a problem with that. The problem is that it's non-negotiable, so your hands are tied. So I guess the second...
And that it's discriminatory on the basis of where...
Exactly, and I think the reply to that, if I was the Ministry of Commerce, would be, well, we have to protect our Chinese consumers of technology because they're dealing with someone so far away and we're unsophisticated. At least that was the argument 10 or 15 years ago. There were some apparently high-profile cases where they didn't get leading-edge technology or it was fraught with legal risk. To me, that doesn't carry much weight today. And there are all sorts of other implications as well. For example, China wants to engage in mass innovation, some kind of mass open source type innovation. Well, if you, in another aspect of this law, all the improvements are required to vest in the party that improve the technology, and that's non-waivable. Well, how does that mesh with an open source commitment to return the improvements to the open source community? It seems to me it's utterly inconsistent, depending on the open source license. So, this kind of one-size-fits-all consumer protection mode, I think, is ill-suited to the various ways that technology collaboration operates. Last example of that, by the way, is government-to-government cooperation. The standard science and technology agreement that the U.S. has basically says that we'll decide by mutual agreement who owns the technology or any improvements derived from our collaboration. So if USDA cooperates with the Ministry of Agriculture, it seems like the non-negotiable provision is that the Chinese own any improvements, notwithstanding what the bilateral template provides.
I'd like to ask the panel, do you have any suggestions for improving the climate, licensing climate in China in particular, in other jurisdictions? And specifically, what can the U.S. government do to improve the licensing climate abroad?
Don't allow the Chinese authorities to threaten the life of licensors. There's a Washington Post article, I'll leave it there, about my experiences. That would be big. Oh, sorry, I said the one thing that I think would be very helpful would be to encourage the Chinese not to threaten the life of potential licensors. There's a Washington Post article about my experience and others of similar nature, and there are more important things in life than getting a patent license royalty, like life, family, friends, So that would be pretty big on my...
Any IP-related suggestions?
I guess more respect to the for the words of the laws that they that they actually signed, and in reality, right? And it's the practice of these treaties that they sign, as opposed to what actually says in them, right? And that's really what I've learned the hard way, and so. Creating mechanisms to hold them account, to hold different foreign countries to account for violating the law or the spirit of what they've signed. But also, I think also, on some level, and I think you told me not to say this, but also, ensuring respect for IP at home, because frankly, when the U.S. gets a cold, everyone else gets really violently ill. As soon as the IEEE passed their thing about a small assailable component, everyone was trying to shove that down my throat from every government around the world. And so any idea that happens in the U.S., however academic, that is designed or could be used to encourage licensees to pay less royalties is taken up immediately in this today of the World Wide Web by foreign countries and foreign companies as sort of a shield against paying any royalties, and it's used and abused beyond any recognition. We all know the small saleable component is a jury instruction type of thing, but why is it being enforced by the Chinese antitrust authorities? So anyway, that would be my thoughts.
Yeah, of course, I'm from the U.S. government, so I can't really talk to myself about what I should do better. I think I'm doing an okay job, but
you're doing a great job.
Oh, thank you, David. I knew there was a reason we brought you here. But just a couple of things, just random things in terms of that, because I think it's a valid question. One is, in fact, there is this law, judicial interpretation on detention of foreigners for any civil proceeding. And they've apparently made it a little bit more demanding in order to have your passport seized while a civil proceeding is pending. But it still exists, and I know certainly with respect to InterDigital, they were afraid of this. I think Qualcomm executives may also have expressed some fear. And frankly, when I was in the embassy, I remember one of the more...
There's a support group, Mark.
There's a support group? Yeah. Well, when I was in the embassy, one of the more painful moments for me was I got a phone call from the Citizen Services Department of the embassy where an American in a central Chinese province who had a heart condition had been sued for patent infringement, and the court had taken away his passport, and he had offered a bond well in excess of the amount claimed, and he was not permitted to leave the country. So this was outright, blackmail, whatever you want to call it, and it was very painful. There are, although it is an IP issue, there are these overarching concerns that can make it extremely difficult. Some lawyers are actively advising on that area. To the point about U.S. SCOTUS decisions and other developments, obviously, we're all affected by that. I will say that over the years, there have been many instances where Elaine Wu, myself, and others, Dave Kapos, and others, when we've heard of important decisions, we've tried to seize the moment and trying to structure the Chinese response, because they read those cases pretty darn carefully, and they take some comfort from it, at least rhetorically. They're willing to use it in response to any criticisms, and it does help if we don't ignore it and try to structure it in terms of the on China. I find that one of the easiest ways of engaging China, but not the most effective, is this is what the U.S. does, you do it too. We're not trying to urge that in the case of those cases. You have to really go to the other level, which is, this is really good for you or not good for you. In some cases, it may not be in China's interest to follow U.S. precedent, or cases, in one matter actually involving data supplementation, which Sherry pointed out, China has a law, the law and legislation, Article 84, prohibits retroactivity of newly enacted laws to restrict previously granted rights. So as China progressively had more demanding rules regarding data supplementation, we were able to raise the issue of whether that was consistent with Article 84. The U.S. has no similar doctrine. And some people would say, well, gee, why are we advocating something with China that we can't do ourselves? Well, it's good for our companies. That's the reason we're advocating. And it actually isn't such a bad concept. It provides stability in the legal system. Those are much more difficult legal arguments to make, but it seems like it should be part of our advocacy armaments.
So on a much shorter answer, given that, I guess we have very little time, but I'm forced to observe that the NTP, so the National Treatment Principle, is given a lot of importance and is taken very seriously in international trade, right? Where violation of the NTP can actually lead to retaliatory measures. And you do have WTO, so World Trade Organization Committee, actually discussing cases brought forward by countries on violation of the NTP, right? And perhaps taking actions. Well, in the case of IP, there is no such things as far as I'm aware of. So there is no WTO committee or like a TRIPS subcommittee, so to say, that would actually discuss these issues and take measures, right? So one practical recommendation would be actually to set up one such WTO committee. I'm not sure it's going to be very efficient, but at least the issues is going to be discussed and put forward.
If there are no further comments, we're going to finish about 2 minutes earlier. And I would like to thank our panelists for this interesting discussion and the audience for their questions and attention. Thank you.